Good morning. Good morning. Good morning. What day is it today? It's August 1st. I can't believe it. It is Tuesday, August 1st. How are we already in August? That's bananas to me that it's August, but it's August. It's Tuesday. Today I've got tea. It's a very full mug of tea. We've got tea, we've got cursey words, and we've got a little bit of a change of programming today. So I'm very excited. Replay crew, there will be timestamps down below. We have 2 streams today. So we are going to stream all the Kohberger stuff on this stream, and then we are going to pop over to a second stream and cover a live hearing in the Rust case. That hearing goes live right around noon Central if the court's running on time. My goal is to pop over to that stream as close to noon Central as we can, pause that hearing so we can watch it live, give you a little bit of a rundown of what's happening in that hearing today. It's a big hearing for them, and breaking down a little of what's going on in the Rust case before that. But before we do all of that, there's been a lot of stuff going on with Rust. At the end of last week, when we were talking all about Shabusiness, when we were talking all about Shabusiness, there was a document dump in Rust, including a few motions that we're going to go over today. I am not going to bore you with the legislative history of the Constitution of the state of Idaho. Where are we today? We're in Idaho. And then we're in New Mexico. I don't know what airport I'm flying into anymore. In Idaho. But I am going to give you a rundown of what that motion to dismiss is, the second motion to stay proceedings, and the state getting real sassy about that alibi notice. We're going to talk about what that's supposed to be, what it actually was, and man, oh man, it's a little messy. The state seems annoyed. The state seems annoyed. That's where we're at with the state. The state seems frustrated with the defense. This case has a lot of paper, even for a death penalty case. A lot of death penalty cases have a lot of motions. This one has a tremendous amount of paper, more so than most. So let us get to it, right? We should just roll the intro. Do I have the intro up? We're professionals here. Of course we do. Let's just go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Members, it's so exciting to see you sharing your member chats and your new gavel colors. It's really exciting. And Jay, Michael, and B2, thank you so much for the gifted memberships. Also, a huge shout out to Streamyard. You guys know that I have worked with Streamyard for a while. I'm very happy to be a Streamyard partner. Here's the thing I love about Streamyard so much is when I was like, hey, the one thing that would make my life easier if you could like auto save our super chats so that when we're in trial, I know I can get to them. And so that Miguelina, when she's producing, isn't also trying to make sure we don't miss super chats and that I'm not going to miss a super chat. Well, I said the next thing is that we get member chats and member celebration chats. Can we work on saving those as well? And today, StreamYard is implemented so I can pull your member chats up on screen and see all of them too, just like super chats. And we're 3 minutes in. I am fucking thrilled about it. I am thrilled about this. This is so exciting to me. So now when you use your member chats, not only will I see them on the back end, but I will be able to pull them up and share them with the community. So we will be doing that throughout the stream. So StreamYard, thank you again for when they say, what would make your streaming life easier? And I say this, they go, okay. And then they do it. It's so incredible. I appreciate a company that's like, hey, can I make your life easier? And I'm like, yes, this. And they're like, got it. 10-4, good buddy. We got you. And then they do. It's absolutely fantastic. I feel so supported. I'm going to try to wield this power elsewhere. Starbucks. Excuse me. You wait too long in between pumpkin spice season, and I'm not okay. I need the dopamine from the pumpkin spice. Okay? So I'm going to need you to please not end pumpkin spice season so early. Let's see if that power works too, huh? Let's see. Let's see. Let's see if it does. Let's see if it works. I don't know. We'll just wave our magic law nerd wands. Oh my God, I see all of your member chats. I'm going to be pulling them up throughout the time as we talk. I'm so darn excited about this. I'm so darn excited about this. And StreamYard has been tremendously gracious. I know that we are actually one of, you guys might not know this. I didn't know this. We are one of YouTube's top streaming channels, particularly when you take out the gaming channels. But even when you leave the gaming channels in, we are at the top of streaming channels just based on the amount of people we have every single stream. So with all that happiness, let's dive into Idaho. There's a new notice of hearing. Good God. Okay, this is the same. All right, this is the same. Here's what's going on in Idaho. August 18th, there's going to be a grip of hearings. I'm going to be in LA during that. And remember, in Idaho, they release the hearings after the hearing's done. That's going to be a really long one. But because I'm going to be on a time zone delay, I will stream that entire hearing when it is released. So it's going to be a lot, but we will cover all of those hearings. Because here's what's going on August 18th. We've got the state's motion for a protective order, which probably won't need to be taken up because it's like, some things don't need to be made public. That's fine. The motion to reconsider the stay for speedy trial, that they might actually win that motion, so they'll need to talk about that. The motion for a scheduling order, they definitely need to talk about that. But then they also need to talk about the orders with regard to the familial DNA. So those are the discovery motions. And they're going to talk about the defendant's second motion to stay, which we're going to go to next. And then the motion to dismiss the indictment, which is probably going to get denied, but we're going to go to that after. So first, we're going to go to the second motion to stay. Then we're going to go to the constitutionally based motion. Then we're going to go to the state saying this alibi defense isn't an alibi defense. Your Honor, Mom, Judge Mom, not Judge, Judge Mom, can you please make them tell us or not? One of the two. Make them tell us or don't. And that's what's going to happen here. So what did I say we were doing first? The second motion to stay proceedings. Emily, you said the second motion to stay proceedings is what we're doing next. And that is indeed what we're doing next. If it feels like we're just jumping right into it, we are, because we have a court hearing after this. And I have tea this morning. I'm really excited to see if it helps with the voice not getting all cranky. It's so hot to drink hot tea, though. I wish it was cold brew. It's not, though. It's pretty decent. Oh my God, you guys, your member chats are so good. It's so good to see them. Irish says, Emily, with great power comes great responsibility. Uncle Ben, use it wisely. I would like to change the world to make sense. Here's something that I really think would make sense. Law nerds, maybe I'll put up a poll. About this. This is something I probably have no control over, but I want to control. Here's what doesn't make sense to me. When we board an airplane, hear me out. Why are we not going back to front? Like, why are we making people get into seats and then push past to the back? Why don't we just load it from the back of the plane to the front of the plane? And I get it. If you want to load first, load first so you can give people champagne, but then load the rest of the plane from the back to the front. So then I'm not standing in my row trying to put a suitcase in, and you can't get around me in a plane aisle. I am trying to get my luggage up into the thing because my carry-on is all of my technology. So I'm trying to get that into the overhead. And then somebody's trying to squeeze around me to get back to their seat. If you just let the back load, then they could put their stuff in and nobody would be trying to squeeze past me in an aisle. And I wouldn't be trying to squeeze past anybody in an aisle. And then all of the lovely flight crew is like, we need to keep it on time. It's like, you can't keep it on time if we're all squeezing past each other in these tiny ass aisles. Go from the back and then load to the front. And then no one is squeezing past each other in the aisle. Why aren't they doing this in the US? Anyway, I've asked my mom about this a million times. My mom was a flight attendant for over 30 years. Shouldn't the plane, wait, I'm going to make this poll better. Planes should load back to front. Yes or no? That's it. There's no in between on this. I know we're getting divisive early. I don't know why this doesn't work. Airports, depends on where you are in the world. Most in Europe will load both front and back. See, if they had two doors, that would make sense. But the thing that makes no sense with the planes that only have one door is if you load the chunk in the back, there aren't as many people squeezing by each other because it's the pause to put stuff up in the overhead is what takes time. And give people a minute to get into their seat without trying to like crush past them. I need to get things out. Like, just let's make it a little bit better. Let's make it a little bit better. That's all. Let's just make it a little nicer to everybody. Okay, let's make the world a little easier of a place to live. I'm going to move this tea bag in a minute. All right. It takes longer back to front, actually. I'm sure it's been studied. I don't know how it's possible that it takes longer because the squeezing past in the aisles is the thing. That's the thing that slows it down. And then everybody's like, I just need to get past you. But if the people at the very back loaded first, you wouldn't need to get past anybody. You just need time. Sometimes you need a minute. Okay. I think we just need, you want order in the flying tin can. I do. I want order. Here's the thing. I just want people to not be so stressed getting on a plane, right? Just don't be so stressed. Just don't be so stressed. Okay. This would only work if there were side seats. But anyway, let's, the world in my likeness. Let's do things logically. Sometimes my logic can be disproven. I would love to see the studies. I need to ask passenger shaming. I'm sure passenger shaming knows. So let us continue. Kohberger. Emily, have you shared your screen yet? No, I sat down and started streaming. It's that kind of a day. Look, here's the thing. I just want to go play Pokemon. That's where my brain's at today. We're at the end of Adventure Week. My youngest and I have been having a really nice time playing Pokemon together. He's gotten some shinies that I haven't gotten. I just want to go play. We found a route in our local area. We're just going to go play a little Pokemon later today when hopefully it's not so hot. So here we go. But first, let's talk about this. What is this? This is the second motion to stay. Hold on. Let's give a quick road so far just on the motions to stay. Idaho, so much has happened. Motion to stay. The defense filed a motion to stay proceedings. Here is what they are trying to do. They are trying to like timeout pause without the clock running down. So without the clock running down on the speedy trial right? Like, excuse me, Your Honor, can we just pause it? They did that. The court gave them like 36 days or something. The prosecution was like, I don't think you can just give them like an extra 36 days. I think that could be read as waiving their speedy trial right. And I don't think that's what they want to do. And they haven't waived their speedy trial right. And please, Your Honor, you can't do this. The statute that they have quoted over and over and over again in Idaho says that if there is something wrong with the way that the grand jury is impaneled, the way the grand jury is selected, then you can stay the trial to like fix it. You can stay the speedy trial clock. That's not what happened yet. So with that, they are now bringing a second motion. Now we know the defense has had time to review the grand jury transcripts and the grand jury proceeding. And we know that the state is arguing against the first stay. I think they have a pretty strong argument against the first stay. This is now the second motion to stay. This is separate than the motion to dismiss that we're going to get to next. This is just a motion to time out, right? To pause. Kimberly, I agree with you. I wish we could enter more than 3 showcases too. I agree. I love the name Moriarty. I hope that's your given name. That's amazing. Throat coat tea is awesome. I agree. I have a couple different varieties. All right. Comes now, Brian Kohberger, through his defense attorneys. Great. Idaho Code 2-213, that's the one we've talked about so much, provides for a stay of proceeding upon verified allegation of failure of Title II of the Idaho Code, filed in conjunction with this motion, but under seal as a sworn affidavit alleging a failure of Title II. So they are saying something happened. Kimberly, I see you in the chat. I love that married name, but yes, I would be like, yes, please. I need that name. It's amazing. So they are filing what they think was the anomaly with the grand jury selection. It's just the jury selection process. Title II provides statutory authority and requirement for convening trial juries and grand juries. Kohberger alleges a failure of full compliance with Idaho Code 2-208. This statute states that individuals must be randomly drawn from a county jury list and that the jury commissioner shall draw a requisite number of qualified jurors for one or more panels. And did they not randomly select them? I can't imagine that's the case. Maybe it is. Weird shit happens, right? Have we learned anything in covering cases, Emily? Weird shit happens. Weird shit happens. Individuals must be randomly drawn from a county list. That's generally how it happens. The statute further requires that upon receipt of the direction and in a manner prescribed by the court, the jury commission shall publicly draw out. Is this the issue? Is the issue that they weren't publicly drawn? Shall publicly draw at random by use of a manual, mechanical, or automated system from the county jury list the number of jurors to be specified. I mean, they don't do it publicly. They do it by computer, or at least I am basing, this is supposition. I am basing this off of my experience. Those lists are generally created by computer now. And then the mailers go out. They create it by computer and then the mailers go out. What do you mean publicly? If that's what they're hanging their hat on, it's going to be interesting. 2-208 requires that the qualification questionnaire form must be completed and returned by the clerk within 10 days from the date of mailing. The questionnaire shall elicit the name, address, and residence and age of the juror. I wonder if the questionnaire has those things pre-printed on it. Most jury questionnaires that I have seen have your name, address on them, and sometimes your DOB, but not always your DOB. They ask the ability to read, speak, and understand the English language. Not all jury questionnaires do that. Sometimes the courts inquire when they come into court. Questions regarding disability impairing their capacity to render satisfactory jury service, or has lost the right to serve on a jury because of a felony conviction. I've seen that on almost every jury form I've seen. The qualification questionnaire shall contain the prospective juror's declaration that the responses are true. Based on a review of the grand jury materials and process, it appears a failure has occurred. What did they not ask? What have they not asked? Now I'm curious, but that's all filed under seal. I'm wondering if they're arguing a defect with the grand jury questionnaire. Even if there is, and this gives a stay, the practical event is they just do it again. It feels... Madeline says it feels like they want a juror bingo event, right? With the big cage. The way I fucking love bingo. I am such, my heart is a much older woman than I am. I love bingo. I love bingo. I love bingo on a cruise ship. I know. My life is riveting. I really enjoy bingo. I enjoy chatting with people at bingo. But it feels like they want the big bingo cage, not even the digital bingo, but the big cage where you just pull out a number. It feels like that might be what they want. I wonder if the questionnaire didn't ask it particularly enough. I guess we'll see when this comes up. Further, other irregularity exists within the grand jury process, and further investigation is necessary to determine the impact. I don't know if that's going to happen, but the irregularity in the selection process is the only thing that gives them a stay. Look, here's what I'm going to say. I don't know how far this will go, but if the court says, yes, your jury questionnaire didn't ask if they had the ability to read or speak or understand the English language well. It didn't ask the things it needed to ask, which would be surprising because these are standard forms that are used in every case, and somebody would have raised this and they would have fixed it, but who knows? The practical event is that this pauses and you can panel another grand jury and do it again. The practical of all of these motions is that it seems that the defense wants more time at this point. They are filing the motions they need to file. These defense attorneys have done their job. They are filing a ton of motions. A lot of these aren't going to work, but they have left no stone unturned. And so they have preserved issues for appeal. They have left literally no stone unturned. It's a legal motion they're allowed to make. I don't know if it's the practical event or the practical impact of this is it might buy them a little bit more time, and it's keeping the prosecution very busy. So we will see if there is a technicality here, because again, this is a very specific code section, and there has to be a problem within the selection of the grand jury. And we will see if there is. I will be surprised if there is, but we will see. Part of it's under seal, so we can't see. We will just see what happens. All right, let's go to this motion to dismiss. I'm sure you've watched other lawyers cover this. I am going to summarize this motion to dismiss. Once they say dicta like more than 3 times in a motion, you're probably pretty screwed. And if you are going to legislative history, it's because you have no other room to argue. Like, you've gotten to dicta. Let's talk about what dicta is before we all just giggle. Yesterday I was playing Pokemon with G. And at some point he was trying to catch a Pokemon with a regular Pokeball, not like a Great Ball or an Ultra Ball. And I was like, buddy, that's an evolved Pokemon. Given your Pokemon level, you're going to need to like throw a bigger ball at it because it's going to eat all your balls. And he looks at me and goes, Ayo. And I was like, you have an older brother. That's where we're at. That's where we're at. He's like, Ayo. And I was like, we can't talk about Pokeballs anymore. All right, let's talk about dicta and Pokeballs real quick. Let's swoop. Let's do this motion to dismiss. I'm very interested to see the state's response. Dicta is the part of a legal ruling that isn't like the meaty part of the ruling. How to describe it? It's the extra bits. It's the just chatting of it all. It's the maybe the foreplay of the ruling. It's not the goods. It's not the ruling that courts have to follow afterwards. It's the extra bits that, you know, are in any given ruling, but it's not the actual holding of the case. So when we're talking about in dicta, which you will see in a lot of this, when they're saying in dicta, they mean just in passing, the court said this. Like, that's not the holding of the case. That's not the law that we're taking away from this and following. It's the court wandering or pontificating or chatting or wandering, but it's not what they are holding. The holding of the ruling has legal weight. You want to or you need to follow that legal weight or argue that it shouldn't be followed. But the dicta is not quite that. So in the chat, Abadi, is that how I don't think I pronounced that right because it went flying by. Adibia. No, I'm going to do that badly. I'm going to say it wrong all the time. I'm going to try to pull it up. But the statement was dicta is Latin for stuff said. Yes, I was trying to make dick jokes about it. It is the stuff said. It's the extra. It's the paradise by the light of the dashboard clock, except it's non-binding. My 9-year-old just laughed at balls. We're talking about balls and dicta today. Balls and dicta. Not Mike Dicta, chat. Not Mike Dicta. Thank you, Octo, for explaining my child's amusement with me talking about a Pokemon eating balls. So this motion is arguing dicta. It's arguing legislative history. It is stretching and reaching more than any commentary YouTube channel you have ever seen. It is the It is the furthest reach you will ever see. But again, they're making the motion. The prosecution has to file a response. The court has to deal with it. It's just not, it's not going far. But let's talk about their particular argument, because again, they are reaching for the grounds to make this happen. All right. Let's see. I saw some of you saying it's strange seeing a normal size mug. I know, I don't have a giant coffee one. These are almost gone for the year. These are the Pride mugs that came out of the vault. These are almost gone. So in the laundered shop, these mugs are at the end. At the end. So if you love it, today is your day. All right. I know this mug is a little on the smaller side for me too. I get it. Motion to dismiss indictment on grounds of error in grand jury instructions, or in the alternative, remand for preliminary hearing. They are arguing in sum that the grand jury burden of proof under the Idaho Constitution is beyond a reasonable doubt. No. The standard at that stage of the proceedings for the grand jury or for a preliminary hearing, let's talk about the difference real quick, is probable cause. These are probable cause hearings to hold over until there is a trial. At trial, the standard is beyond a reasonable doubt. They are arguing that that is a misinterpretation of the Constitution in Idaho, and the grand jury needs to be given the standard of beyond a reasonable doubt. But the grand jury is an investigative and sometimes charging entity, and you can either go grand jury or preliminary hearing to get to probable cause. Someone has to decide probable cause. It's either going to be a grand jury or a judge. Probable cause. That's not beyond a reasonable doubt, which is the highest of the standards. This is seems like enough. Yeah, that's it. It's likely that this person did that thing. Sure. That is a very different standard than beyond a reasonable doubt. Beyond a reasonable doubt is our highest standard in the land. So they are arguing that the grand jury at the initial stage of the proceedings needs to also find beyond a reasonable doubt, not probable cause. It's so funny. Mama Bear in the chat said, sounds like a law school argument. This feels like somebody wrote a law review article on it, and then somehow this became part of motion practice. I wonder if this has been filed in other important cases when a grand jury has been used. I wonder if this has come up. Question, is the lawyer unaware of the law? They're literally making the argument. They're aware of the law. They're just saying, but shouldn't it be this other way? And it seems from this motion that the Supreme Court has said, no, the standard is beyond a reasonable, or no, the standard is probable cause, not beyond a reasonable doubt. And they are saying that they are arguing that the Supreme Court does not have the ability to change what the Constitution says, and that the Supreme Court's ruling that probable cause is the standard goes against what the Constitution says. I disagree, but I don't practice in Idaho. The judge is going to be like, are we doing this? If Judge hasn't seen this motion before, which they may have, this might be the kind of motion that comes up in every single case that is, where there is a grand jury, which it seems like Idaho does a lot of preliminary hearings and grand juries don't happen all the time. And so this might come up on occasion, and it's just like, okay, this again. The Supreme Court has already said that the standard is probable cause. Therefore, the standard is probable cause. Thank you for your motion denied. Let me sidebar myself. If this gets granted, walk with me on if. Here's what happens if this gets granted. If this gets granted and they throw out the indictment from the grand jury, the prosecution can refile the indictment and go to a grand jury again and do this all over again. New speedy trial clock. Or They can throw out the entire indictment. The prosecution can refile it, start the speedy trial clock again on the new complaint, go to a preliminary hearing, and then start that speedy trial clock again after preliminary hearing on the information. Remember, the 6-month clock starts at the information. So if they have to go all the way back to the beginning, they have to do that 90-day clock first from arrest and charge to prelim or indictment. So that clock starts over. And then once you get an information, then that 6-month clock starts again. So that's what, 9 months now? So this would start it all the way back at the beginning. Kristen said, would he stay in custody? Yes. They would probably do this the exact same day. It's like, oh, you're dismissing it? We're refiling. And a dismiss and refile happens. A dismiss and refile isn't shocking. It happens. Sometimes things come to prelim and the witnesses aren't there, and the prosecution will dismiss and refile the same day, and the person gets refiled on the exact same charges, and it starts over again. The prosecution can only do that once. There are some circumstances when you have a refile after like a hung jury or something that's different. Generally, at this stage in the proceedings, you can only do that once. That can vary by jurisdiction. But the impact of this is buying more time if it works. If it doesn't work, it's just burning paper and time that the defense has to do other things. So here we are. So we're going to talk about it real quick. I'm going to tell you what I think of this code of the what I think the Constitution is saying here. Note, I am not a constitutional scholar. I do not spend all of my time reading old shit. In fact, I spend most of my time reading shit that you'll see on Book Talk. Constitutional law is not my favorite. I enjoy looking at how different courts over time interpret the Constitution, but also I am not a constitutional scholar. Just so we're clear. I very much enjoyed my practice being on my feet in front of a jury. I did not want to sit in my office and just do paperwork. I did that at the beginning of my career and I hated it. It was like, oh, you want me to sit in an office all day and talk to no one? No. Maybe now I would like that better. No, I wouldn't. I like to talk. All right. Idaho Constitution, Article 1, Section 8. And IC 19-1107, not 007, 1107, 1107. I saw a question here. Philip, I'm grabbing your question for when we get to Q&A. Love reading all the filings when I was a paralegal. If it's my own case, yes, but it's not. I want to practice litigation. Sometimes you need to do it. All right. The legislative history also supports beyond a reasonable doubt. When you're going to the legislative history, you're going to like what they chatted about when they made these rules. The Idaho Supreme Court cannot adjust the standard of proof as it is a substantive right. So the ruling of the Supreme Court can't just change what the Constitution says. The failure to properly instruct a grand jury as to the standard of proof is grounds for dismissal of the indictment. They are saying the grand jury was erroneously instructed that the standard required for a presentment, I think this is indictment. The grand jury was instructed with the standard required for a presentment. Thus, this court should treat the indictment as a presentment. Idaho's got a little bit of a quirk with whatever the hell a presentment is. And they are arguing that the grand jury did not indict Brian Kohberger because they did not use the beyond a reasonable doubt standard. They issued a presentment, which was under a probable cause standard. What? Argument: the Idaho Constitution set the standard for proof of a grand jury at beyond a reasonable doubt. Here's what it says, pursuant to IC 19-1107. The grand jury ought find an indictment when all the evidence before them, taken together, if unexplained or uncontradicted, would, in their judgment, warrant a conviction by a trial jury. The argument that Kohberger's attorneys are making is that the warrant a conviction by a trial jury fixes the standard at beyond a reasonable doubt because that's the standard for a trial jury. However, the process at this stage in the process means that an indictment means that you believe that it should go to a jury, that there is probable cause to believe the person before you is the person who did the things that are being alleged, and that should go on to a trial jury. So when we look at what the Supreme Court in Idaho said, I imagine what the Supreme Court in Idaho said. Have I read that part yet? No. I imagine what the Supreme Court in Idaho argued is that this means that the case should move forward. The case should move forward to a trial jury. Like, yes, there's enough here to move it along in the process. But I understand the argument. This is not a nothing because the language is not super clear. The language says warrant a conviction by a trial jury. Does that mean there's probable cause to believe it should go to a trial jury? Or does that mean that is the exact same standard as a trial jury? So while it feels like they are splitting hairs, sometimes that's how law gets made. But every grand jury everywhere is on a probable cause standard. So if every grand jury everywhere is wrong, or at least every grand jury in Idaho is wrong, that'll be a very interesting thing. But this is a very splitting hairs kind of an argument. However, if my family member is convicted of a capital crime, the lawyers I want are the ones that are willing to split hairs because you preserve all the issues for appeal and you never know. You want the lawyers that have the fight in them. Tracy, is this fairly normal? This is outside the bounds of traditional motion practice, but it might be normal for them in Idaho. This might be a motion they bring with every single indictment because of the quirk in the language in Idaho. The standard in California was much clearer that it was probable cause, and this particular issue never came up. It's just an indictment's probable cause. So this team is fighting for their defendant, which is what you want. And I think it's what the victims' families want too, because when you have a defense attorney that's fighting, if there is a conviction, especially in a death penalty case, you want to be sure that the state not only has the right person, but it's not going to get overturned on appeal for 50 years henceforth, if that makes sense. Just me said the presentment motion was so painful though. Yeah, I'm not reading the whole thing. To you. This lawyer is proving why she is approved for death penalty cases. This is not new to her. She's definitely done a thing or two, and they are doing their job. Like, these attorneys are working this case. And for that, I am grateful and sometimes tired. Right? Sometimes tired. Okay, let's keep going because we have one more motion to get through before we pop over to New Mexico. And we've got some questions. The statute was in existence at the time the Idaho Constitution was adopted in 1887. When construing the Idaho Constitution, the primary objective is to determine the intent of the framers. Provisions of the Idaho Constitution must be construed in the light of the law prior to their adoption. So they are looking at the law, this law, prior to the adoption of the Constitution. When you have to go back before the Constitution was adopted, it's because your argument is not clear. In Clark, the Idaho Supreme Court found a statute in force at the time of the Constitution was ratified to be controlling in its interpretation of Article 1, Section 17. In State versus Matthews from 1997, not Dave, but you see where my brain's at. Quote, our Constitution considered the issue of whether search warrants need to be signed in order to be valid. The court found that warrants do need to be signed, or else a search pursuant to such warrant would violate Article 1, Section 17 of the Constitution. The court arrived at this conclusion despite the fact that Article 117 is silent regarding whether a warrant needs a signature. The reason the court was able to find a constitutional violation in the case was by acknowledging that the statutes which require a signature predate the Constitution of the state of Idaho. Because those statutes which require a signature on warrants predated the Constitution, they, quote, create a substantive right which existed prior to the adoption of the state's Constitution. Smoke signals, I am totally fine with that. All the pre-boarding, do all the pre-boarding, and then back to front. That's all I'm saying. All the pre-boarding, and then back to front. That's all. Let's see. The Roch court was able to trace this deeply rooted heritage all the way back to 1603. Friends. Again, because our country is young, we don't go back as far in law as others. But when we're going back to 1603, my question is always, has no one sorted this out before 2023? I had to call my my retirement plan for when I left the DA's office over something that we are sorting out that happened in 2011. And for me, I was like, when? You 2011. I'm like, that's a bit far, but we need to handle it. 1603, dating back to 1603. I appreciate whoever wrote this original article. If the Magna Carta pops up, somebody's going to get a bingo. Thus, it's a deeply rooted heritage back to 1603. Thus, whatever this language means, it must color this court's interpretation of Article 1, Section 8. The section states, no person shall be held to answer for a felony or criminal offense of any grade unless on presentment or indictment of a grand jury. Those are different things. What is a presentment of a grand jury? I don't know. I know exactly what an indictment is, or on information of the public prosecutor. That would generally be after a preliminary hearing, because after a preliminary hearing, you get an information. So when you're originally charged, it's a complaint, you go to preliminary hearing, and then it's an information. After a commitment by a magistrate accepting cases of impeachment, in cases cognizable by probate courts or justices of the peace, and in cases arising in the militia when in actual service, separate court system, in time of war or public danger, provided that a grand jury may be summoned upon the order of the district court in the manner prescribed by law, and provided further that after a charge has been ignored by a grand jury, no person shall be held to answer. So if a grand jury does not give you an information, then you can't be held to answer. Being held to answer means held over to trial. You are held to answer for your crime over to trial, or for trial thereafter upon information of a public prosecutor, which means the prosecutor brings the charges, because grand juries can also bring charges. If it were not clear from the text of Article 1, Section 8, the framers' general intent behind the section was to ensure that either a grand jury or magistrate stood between the prosecutor and the accused. And that's what happened here. Either a grand jury indicts you or a judge holds you to answer on a preliminary hearing. That's what happened here. You can't just have a prosecutor hold you in custody forever and then go to trial. There has to be a step in between to determine that the person being held for the crime being charged can go through to trial. And that's what happened. Thus, it stands to reason that the standard of proof in effect at the time of the adoption of the section was incorporated into it. It would be rather ineffective to create a buffer between the government and the citizens that the government could change willy-nilly. I don't think there's any willy-nilly shenanigans happening here. However, that does not provide much information as to what standard would warrant a conviction by a trial jury actually means. I think it's the holdover. The plain text sets the standard of proof that would warrant a conviction at trial. The justification of a conviction at trial, or the standard of proof, is beyond a reasonable doubt. If that were not enough, Section 19-1107 is one of the many laws adopted in 1863-1864, copied verbatim from the laws adopted in 1851 in the state of California. Please, let's not go to another state. We're not going to. I'm not going to. We're not going to California in 1851. We're not time traveling. Then they go through the legislative history. You know how I feel about going to legislative history, but they again are trying to reinterpret the state constitution in the state of Idaho. Which is it reads like it literally reads like a intellectual analysis. This reads like a thought experiment more than something that's actually going to get granted. The failure to properly instruct a grand jury as to the standard of proof as grounds for dismissal of the indictment. If that's true, that's fair. The thing is, the grand jury was instructed, it seems, on probable cause. They're just arguing that probable cause is wrong. I can't wait to see the state's response. Let's see. The grand jury was erroneously instructed with the standard required for a presentment. I don't know how they've determined that a presentment is probable cause and an indictment is beyond a reasonable doubt. I should have probably not zoomed, but we're zooming. There was one final wrinkle in this error worth considering. As mentioned above, there is in Idaho a thing called a presentment. Even the language of this does not sound like their typical legal writing. These lawyers are normally very specific in their writing, very precise in their writing. This reads like an academic paper and not legal writing to me. Which is, I just am curious as to which attorney wrote this and with what input, because this does not read like their other writings. This reads like an academic exploration, not advocacy. As mentioned above, there is in Idaho a thing called a presentment. It does not appear from the authorities in Idaho that this thing is well understood. Who's writing this? Because this is not how the lawyers have been writing this entire time. However, in the words of one justice, which justice, I am not grading this paper right now. It is the only sort of accusation any grand jury in Idaho has ever produced. When was this from? Where is the date on this site? For the information of the court and the bar, a presentment is what our United States Supreme Court would call a term of art. Again, this is not written the way that the lawyers in this case have written. This feels like it's written by someone completely. This could have been written by a research attorney, by a law student. This is not written like these lawyers have been writing. This sentence is so overdone. Practicing lawyers just don't write like this. This is not a lawyer that stands up in court every day saying this. I just don't believe it. I see all of you. What if it was Kohberger? Maybe. Could have been. He's an academic. Could have been, but the lawyers would have had to at least review it to sign their name to it. Because this is such a strange way to word this. This is not wording this in advocacy, and you generally don't need to explain to a court that the Supreme Court calls something a term of art and then defining the term of art. It's just not the way that you do it. Plot twist, ChatGPT wrote it. Chat, you guys are funny. And then they go on what a presentment is. A presentment permits a defendant to request a preliminary hearing, and they go through the history of what a presentment is. Pursuant to Idaho Code 19-1207, a magistrate is to produce on a presentment as if it were an information. Well, if it's an information, it holds you over to trial. At first glance, this likely appears to undo much of what has come before. After all, if a presentment is an information, then it already has had a preliminary hearing. Yeah. However, history being what it is, things are not so simple. This is not legal writing. It's just not. In 1887, when the revised statutes were adopted, an information was the same as a complaint. Once arrested on an information, a defendant had a preliminary hearing, referred to at the time as an examination. Sometimes they are called preliminary examinations. It was not until the code was revised, stick to the code, in 1969 that the terms became separate. Well, when they separated the courts into lower courts and superior courts. Additionally, even in 1887, the word complaint was solely used in the code when discussing misdemeanors, while the information referred to a felony. Which is, I think, why they still use the language in complaint when you're in the lower court, because that is the misdemeanor. Oftentimes, when you're in the lower court, that comes before like the misdemeanor court, and then it gets held over to the superior court, which is more of the felony court and a lot of court systems are separated in that way, especially in larger jurisdictions where they have like 3 smaller feeder courts that feed up into one superior court for all the felonies. Thus, the question becomes, did the legislature change Chapter 5 and leave Chapter 12 alone to purposely turn a presentment into an indictment? The answer is clearly no, nothing is clear. Although the purpose of this individual bill seems lost to posterity, the 1966 Court Modernization Plan of 1969 and 1969 court reforms are still extant? Don't know. In 1966, the legislator wanted a modern court system. Part of the plan was to do away with justices of the peace, police courts, and probate courts, and to have a 2-tiered court system. I just explained the 2-tiered court system. In 1969, much of the court reform recommended was made into law. Great, the history of court reform. Conclusion. Over 150 years ago, Idaho joined the state of California in adopting the Field Code, thereby adopting reforms to the grand jury system intended to restore that system, its function as the bulwark for freedom. The strange history that follows in this state, just as every other state with the same statutory scheme, is both tragic and unconstitutional. No court had the power to decide that the legislature had made it too hard for grand juries to do their work and change. There would be no point to have a grand jury at this stage of the proceeding. There would be no point. There's no point at this early stage in the proceeding to find anything beyond a reasonable doubt. Could a grand jury still indict people? Yep. But there's no point. The stage of the proceedings indicates whatever. I'm not going to argue. I'm going to wait for the state to argue their own motion. No court had the power to decide that the legislator had made it too hard for grand juries to do their work and change the sufficiency of evidence required to indict. Kohberger is asking the court to recognize the long string of error that has led us here. Your Honor, please undo the legislative history of the state of Idaho for the last 150 years. The court is going to be disinclined to acquiesce to that request. And give back the people of this state the protections they are owed. They have them. An indictment or a preliminary hearing are the protections that are in place. The indictment in this matter should be dismissed and remanded for preliminary hearing. This says it's from Jay Longston. He's done some of the other litigation writing. It just reads totally different than his other writing. It reads completely different. We only have a few minutes before that hearing starts in New Mexico. Don't worry, we're going to finish what we're doing here before we fly to New Mexico real quick. So here's what all of this comes down to. This is a very academic argument. This is splitting what is meant. I don't think it's going to go anywhere. But they are making the argument. And I am not mad at them for making the argument, but it is something. Look, I'm here for a novel constitutional argument as much as the next girl. Look, I don't procedurally, I don't see this getting us very far. And I just wonder, does the defense really want to start the speedy trial clock over? Do they really want to go back to the beginning? If they want that, just waive time. You can have more time. You have control of more time. You're the defense. You can just waive time. So, the last thing we need to get to is the prosecution feeling a little bit salty. So this is, where did it go? Where is my... We did the second request to stay proceedings. We did the motion to dismiss. And now we need to do the state's motion to compel. Where did it go? There it is. So next we are doing the state's motion to compel. They were not thrilled with the alibi notice. Let's go to the alibi notice. Let me grab that too. Let me go to the alibi notice real quick. We're going to talk alibis for a moment, right? Let's talk Kohberger's alibi that's not going to fly. In the state of Idaho, you are required to file alibi defense, either within 10 or 14 days of being asked by the prosecution, or at a time that the court sets. This court set July 24th, and the defense filed their quote unquote notice of alibi. And their notice of alibi should lay out, hey, this is the alibi defense. Here, I'm going to pause this hearing. This is the alibi defense. We are going to present these witnesses, and we are going to show that this is the alibi. We'll talk how I feel about alibi defenses at another time. But they have said basically they continue investigating his case, so they have no alibi at this time, and that their denial of the charges does not constitute an alibi yet, and that they are going to cross-examine witnesses. So it's not that they have an alibi witness that is like, no, he was with me, Your Honor. It's not, we're not like No Body, No Crime with Taylor Swift, you know. Gonna swear she was with me. There's no alibi witness here, right? So what he's saying is they continue to investigate. Well, they were ordered to turn over an alibi defense. Their alibi defense was, we don't have an alibi defense, without specifically saying that. So the prosecution was like, what you're not going to do is this shit. So the motion to compel notice of alibi, or alternatively, bar certain evidence. Also, I'm going to tell you guys soon, we are going to move over to New Mexico in a new chat. So if you want to save super chats for the next one, do it. I see the last one came in from Nuance. We're going to get to that, but then we're going to have to switch streams. So just hang in there. Motion to compel notice of defense, or alternatively bar it. Okay, fine. You don't get an alibi then. If you don't tell me what you want for dinner, you're not having dinner. That's it. That's it. Comes now the state of Idaho through their prosecutors, and provide the state with notice of any alibi that may be offered herein. Said notice is to include, this is what the code says, the specific place or places at which defendants claim to have been at the time of the burglary or homicide offenses in this case, and the names and address of all witnesses with whom the defendant intends to rely to establish such alibi. You're saying it wasn't you. So, prove it. Kalo in the chat brought the whole lyric. Este's sister said she was going to swear she was with me. She was with me, dude. We don't have a she was with me, dude. Este's, by the way, also a type of a robbery in California. That's a whole nother conversation for another day. So, if it wasn't you, where were you? Who's going to say you were there? As the court file reflects, the state filed its request for discovery disclosure alibi demand on May 23rd and served the defendant the same day. The parties subsequently stipulated to extend the statutory time for the defendant to provide notice of alibi and comply with the Idaho Code 19519 on July 24th. On July 24th, the defendant filed a notice of defendant's response to state's alibi demand. The document does not comply with the code in that it does not specify a place or places at which defendant claims to have been at the time of the offenses herein, nor does it provide names and addresses of witnesses upon whom the defendant intends to rely. The defense does not have to present an alibi, right? The defense is in the position where they are innocent till proven guilty. They don't have to prove they were somewhere else. So the state is saying, if you're not going to prove you're somewhere else, you can't spring it on us at trial. You can cross-examine witnesses, you can poke holes and lay doubt, but you cannot present an alibi defense if you do not present us the evidence that you're going to. An alibi defense almost shifts the burden sometimes, where then the defense is like, we can prove we weren't there, and then everybody's like, so prove it then. Prove it then. Prove it then. Let's see it. This happened a bit in Murdaugh. At the beginning, in opening statements, Poot was like, and I will in fact prove to you, not just that there's doubt, but that he's innocent. And through that whole trial, we're like, show it. Show it then. Scorpion says, this feels like shifting the burden. Is that allowed? No, it's not allowed. But it's exactly what happens, because once you're trying to prove an alibi defense, the jury's like, oh, so if you're not there, show me that you're not there. Tell me. But the defense has the right to bring an alibi. The defense has that right. But then once you as the defense start to prove things instead of disproving things, everybody's looking there going, show me then. Show me then. That is how human brains work. As opposed to saying the state hasn't shown you, the defense starts pointing the fingers at us. We're going to show you why we weren't there. Instead of pointing the fingers at the state going, prove that he was there. You haven't proven that he was there. And then they can rely on that burden. All right. Continuing on. The state recognizes the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. However, as noted in both of these cited cases, the defendant's right to call witnesses in his defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery from the defendant. The court observed in Juarez, if requested by the state during discovery, a defendant intending to offer an alibi must file notice where the defendant claims to have been at the time of the alleged offense and the names and addresses of witnesses whose testimony will support the alibi. If you're not there, this is not a hard burden. Hey, we've seen this argued in the defamation case. The professor is like, I was at a family wedding in Portland. Who would be the witnesses? Well, the airline that would have the airline tickets, the people that were with them, and then you're like, here's pictures, somebody to authenticate the pictures. You would have stuff. Harder if you're at home asleep. And you're like, I was just at home by myself. You were then. Who's going to testify to that? Do you have cameras at your home? So if you're not there, there should be witnesses that you are not there. As evidenced by the defendant's July 24th notice, the defendant has failed to comply in any fashion with the requirements of the statute, court rule, and case law. It's important to note that the scheduled October 2nd, 2023 jury trial is barely more than 2 months away. Trust me, don't I know it? The speed at which this trial is approaching is freaking terrifying. Terrifying. If the defense intends to rely on alibi, it is essential that they be required to provide prompt notice to the state and fulfill its obligations. Any further delays will substantially prejudice the state's rights. Similar to the situation in Juarez, the state has no idea how the defendant's notice regarding alibi constitutes an alibi, and as observed above, the state is unable to comply with ICR 12.1 and Idaho Code 19519 because, based on the lack of information in this case, we don't know how this is an alibi at all. Excuse me, Mr. Geist, if she doesn't do her assignment, I can't do mine. She's talking about a garden party. This is the prosecution saying we can't fulfill the rest of our obligations if they don't fulfill their obligations. So they either have to say they're not presenting any alibi witnesses or they have to give us the fucking information. But you can't have it both ways, and the shaggy defense isn't going to work. You cannot just come in and be like, oh, actually, you can just come in and be like, it wasn't me. But that's not an alibi defense where you're calling witnesses. The state also notes that the United States Supreme Court observed in Taylor versus Illinois that the ease with which an alibi can be fabricated in the state's interest in protecting itself against 11th hour defenses is both obvious and legitimate. The adversary system of trial is hardly an end in itself. It is not yet a poker game which players enjoy an absolute right always to conceal their cards until played. Based on the above, the state respectfully praised the court for an order compelling the defendant to comply fully with the code, stick to the code, by filing a notice specifying where the defendant claims to have been at the time of the offenses, the names and address of the witnesses who will support the defendant's alibi. Given the time constraints, the state praised that the court direct the defendant to comply no later than 10 days from the date of the court's order, that the state be allowed, pursuant to Idaho Code 19519, to provide defense with written notice of names and addresses of witnesses the state intends to rely on to establish the defendant's presence at the scene of the offense, and any other witnesses to be relied on. Because the state has to provide, like, okay, these are your alibi witnesses. Here are our rebuttal witnesses to your alibi. This all goes down before trial. That the state intends to rely on to establish defendant's presence at the scene of the offense, and any other witnesses to be relied on to rebut the testimony of defendant's alibi witnesses no less than 10 days before trial. They're like, can we give that to you at the end of September? Look, it's August. They do not have a lot of time left. So the state is like, this alibi is not going to fly. You know why? Because so far there's no alibi. There's no he was somewhere else at the time of the crime. There is no alibi. A lot of cases don't present an alibi defense because of the difficulty with alibi defense, because then the defendant is like, let me prove it to you. The job of the state is to prove it beyond a reasonable doubt. Most defenses rely on they didn't prove it. Ladies and gentlemen of the jury, they didn't prove to you that it was this defendant. Not, ladies and gentlemen of the jury, we proved to you that this person wasn't there. It's more rare. And the state is like, you need to tell us what you're doing or get out. We are going to go through a speed run so we can go to New Mexico. All right. We are going to speed run some questions. I know I'm not going to get to pull up all your member chats, and then we're going to go to New Mexico. Don't worry. We'll be over in that chat in just a moment. All right. Speed run, speed run. Speed run, speed run. It's so good to see all of your member chats. Nuance said, last week I experienced an attempted home invasion. That's terrifying, and I'm sorry. Even though I got a good look, I couldn't remember his face afterwards. I get why people challenge eyewitness testimony now, and in this case especially. Yes, because it's very, very difficult. Eyewitness testimony is very difficult. It just depends on the length of the thing and if you know the person, and there's a lot of other conversations around that. But yes, and I'm sorry that happened, and I hope you and your family are well and not completely traumatized. Hello, Em. I love your channel. Was happy to see you on Lawyer. You know, I was happy to pop into the chat and just say hello. Sarah said, could this overturn past convictions? I don't think any of this will be retroactive in these rulings at all. Jacob said, this reads to me that they have a bunch of legal interns who wrote this as a group project. It has an academic vibe to it. This brief definitely sounds like it was written by an academic. It was. Yep. Kara said, I work in aerospace. Yay, woman in STEM. Yay. A good method is 1, disabled, 2, window seats, 3, middle, 4, aisle. Almost impossible to actually do. I love the thought. I love the pre-boarding. I'm here for it. And then you don't have people crushing past each other in the aisles. Question, Emily, what does Kohberger gain by not providing his alibi, saying he'll prove it in court during direct and cross-examination? Why not just end it? He's just like, he's just trying it. That Jan in the chat said that the Rust hearing stream doesn't have the chat turned on yet. Megalina, do you mind turning that on? We're going to swoop over there in just a minute. Jana said, I have a t-shirt that says I hate pumpkin spice. I said what I said. I wear it because it's true. You are more than welcome to eat or drink my share of pumpkin spice stuff. All of the pumpkin spice that normally starts at the end of August. I'm so ready. Please tell me they're not pulling an AH with jury selection. Elizabeth, no, this is a different argument. They are allowed to argue the nuance of the law. I just don't know what nuance they're arguing because it's under seal. But if the law says you have to have sections A, B, and C on the jury summons and those aren't there, then that's a problem. The problem is that it then goes directly back to the beginning and it starts over again. Can we add deplaning front to back too, please? When everybody stands up, when the plane stops, my heart sinks. It's quite a lot. Little behind, excited for the Rust case. We're going to New Mexico in just a minute. Speaking of inappropriate humor this week, I realized that the Declaration of Independence contains the phrase manly firmness. We're going to have to work that phrase in over here a little bit more. Sadly, the Kohberger case is now both our circus and our monkeys. It's a lot of litigation, but again, following a high-profile, high-stakes criminal case from the beginning, maybe hopes to give a whiff of the amount of work that goes into these cases. It is quite a lot. Windows first, then middle aisle. There we go. Well, then you're not climbing over people. Climbing over people does take quite a lot of time, and then you've got to have somebody come out. Elizabeth said, Dave's set lists were insane in West Palm. I saw the set list. I was watching them, shaking my head that I have not seen Drunken Soldier this entire summer. So glad to catch a live. So glad you're here, Janice. All right, y'all. We are about to deplane and go to New Mexico. The public health gal, I'm sick in bed with COVID for the first time with a badly stuffed nose and constant dizziness. Watching you is lifting my spirits. I appreciate you. Well, we're going to do some Zoom court in just a minute, and hopefully that will continue to lift your spirits. So This will redirect. This will take you all the way over to the next stream. So I'm going to be starting that stream in just a moment. Are you ready? We're ending the poll. We're ending the poll. All of you agree. Back to front, 91%. Look at you. All right, everybody. Deplane quickly. We are heading to New Mexico. Thank you for being here. Let's go.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.